Hello everyone, welcome back to the Let's Learn. Today, as this is the Law of Contracts Part 2 video, we will be learning about the next two topics of the index. And the next two topics of the index are free consent and lawful consideration. In first part, we have studied about offer, acceptance and revocation, and then competency to contract. I hope the first two topics from the index are clear to you. And then today we'll be learning the third and fourth topic, and in the next video we'll be learning about special contracts and breach of contract. Hey guys, before we start the video, I'd like to tell you something exciting. The Let's Learn is offering every CLAT aspirant a free trial who registers and fills the Google form in our Telegram channel. You'll be taught by India's top mentors from top NLUs such as NLSIU Bangalore, GNLU Gandhinagar, NLIU Bhopal, Symbiosis Law School and MU. You will be having classes from June 1st to June 7th. This is going to be a menace, guys. I want you to join this and I want you to unlock your potential in law. Let's begin the video. Before we begin today's agenda, I want to explain you all two important topics, which are void and void ab initio. So we'll start with void contract. What is a void contract? A void contract is something which is known as illegal contract. Let's just decode this with an example. We have two parties or two individuals, A and B. So A is a illegal arms and drug dealer, and B is his customer. So without any license of dealing, A deals with arms and drugs, which are banned in the eyes of law, which are considered as illegal in the eyes of law. And if B and A get into an agreement with each other, then this is considered as void, because the contract and the terms of contract where they both entered with each other is illegal. I hope you understood what void is. Let's just study about what void ab initio is. I hope you understood what void over here is, and then what is this ab initio. Ab initio is nothing but, when translated to English, means from the beginning, or since the beginning, or from the start. This is from the start. So which is illegal from the start. So let's say, for example, we have got A again and we have got B again. Their terms of contracts are correct. Their terms of contracts are considered in the eyes of law. But B's competency to enter into contract is not satisfied here. As in last video, we have learned about competency to contract, who cannot enter and who can enter into contract. And B is considered one of them. Let's say B is a minor. A person who is below 18 years old is not competent enough to enter into a contract. And even if A and B make a contract together, then this contract is void. This contract is not valid from the beginning. Even if the terms are very legal, even if the terms are pure, even if the intentions are pure, the contract is considered as void. The contract is considered as not valid from the beginning. So coming up to the third topic of our video, free consent. What is free consent? Free consent is defined under Section 14 of Indian Contract Act 1872. It is not actually free consent, but it is actually consent. So consent is defined under Section 14 of Indian Contract Act 1872. So a consent is said to be free. As we are learning about free consent, the consent is said to be free when it is not caused by the following terms. The first one is coercion. We have mentioned it over here. Coercion, Section 15. Undue influence, Section 16. Fraud, Section 17. Misrepresentation, 18. And mistake of fact, mistake of law, and unilateral mistake are defined under Section 20, 21 and 22. So we'll be learning this further in this video, and then you'll understand what the following terms are. So coming up to the coercion. Coercion under Indian Contract Act is defined under Section 15, and I want to discuss and decode coercion in simple terms with this example I have mentioned over here. So in this example, we have two parties, A and B. So A says to B that, B, if you don't buy my car, he says to B that, B, if you don't buy my car, I will kill your family. When B doesn't want to buy A's car, when B doesn't have the money to buy A's car, and B is not willing to buy A's car, A is forcefully obtaining B's consent. So let's write it over here. Forcefully obtaining consent. He is obtaining consent by forceful means. He is blackmailing B. that he'll kill his family. So B, under serious threat, signs the contract. So my friends, this is coercion. Coercion under section 15 of Indian Contract Act is defined as forcefully or by forceful means obtaining the other party's consent to enter into the contract is known as coercion. I hope you understood this. Let's just jump to undue influence. As we all can notice over here, undue influence is defined under section 16 of Indian Contract Act. So let's also decode undue influence with a very simple example. So you have two parties to this contract. The party one is a guru, a spiritual guru, and the other party is his devotee. So one day spiritual guru says, for blessings of Lord and for your peaceful enlightenment in afterlife, I want you to donate all your property to my ashram. So he says, donate all your property to ashram. And as devotee trusts spiritual guru very blindly, he writes all his property to the ashram. So now undue influence here has worked really well. So this man, the spiritual guru, was in an authoritative position of devotee. And section 16 also says the same thing. When one party is in a dominating position where the party could influence the other party to enter into a contract without very much stress. And this, my friends, is undue influence. It's very simply explained now. I hope you really understood this. Now let's understand what fraud is. So again, as we all can notice here, fraud is defined under section 17 of Indian Contract Act. Fraud is said to be done by the seller when he makes a false statement, when he knowingly does it, when he intentionally does it with a malign intention. So malign here is bad. So with an intention to sell it off, with an intention to deceive the buyer, and also when the buyer gets deceived by the offer, it is said to be fraud. So in this example I have taken here, let's see if the ingredients are satisfied or not. So A says to B that this bike was never been used in 3 years. This bike was purchased 3 years ago and it has never been used. It was not even moved a bit forward. So when B, after going home, checks the odometer, it shows that the bike has run 3,000 kilometers. And the buyer got deceived by the offer when it was made by A, when he said that it was never been used. And when B checks it, he gets a reality check of 3,000 kilometers of odometer. So this, my friends, is fraud. I hope you understood it. Misrepresentation and fraud both go hand in hand. Section 18 is known as misrepresentation. We'll decode that with an example too. So let's decode misrepresentation, section 18, with a very simple example. So you have three parties. A, who is a seller. B, who is a real estate agent. And you have C, who is the customer. So C wants to buy a land. So I'm writing it over here. C wants to buy a land and A wants to sell it. And in between you have a broker, you have an agent called B. So A says to B that this land is 1.5 acres. And as C wants to buy 1.5 acres, he contacts the real estate agent and says that, man, I want to buy 1.5 acre land. If you know any good site, just tell me, I'll just buy it. So B takes C to A's site. He asks C to just look at the land and confirm it. C looks at the land and he says, okay, just fix the land, I'll buy it, I'll make the payment to you, just give it to A. So later, what C discovers from the papers is that the land is only 1.25 acres. Turns out, false information that makes another person to agree to something, but without deliberate cheating. In fraud, the other party, who is the offering party, deliberately falsifies the statement in order to deceive the customer or deceive the offeree. So here, what they do is that without any deliberate intention, without actually knowing the facts, with a genuine mistake, believing it to be true, deceives the person over here. So I think section 18 of Indian Contract Act, which is misrepresentation, is clear to you all. Now let's understand the three major sections under mistake. So coming up to mistake, guys, we all make mistakes. So in contract, mistake has a very specific definition. So mistake is also divided into three parts. The first one is mistake of fact, the second one is mistake of law, and the third one is mistake of fact by one party. So this is known as a bilateral mistake. So you might have heard the word bilateral, where two nations play cricket, two nations play football, and this is known as unilateral. So bilateral is when two parties make mistakes about the contract, and unilateral means when one party makes the mistake. And mistake of law is we'll learn further. So coming up to section 20. In this rule, when both parties are under mistake of fact essential to the agreement, when the both parties are mistaken about the terms and conditions of the contract, then the agreement is void. Let's decode that with a very simple example. So in this example, you have Aurora and Bose. So Bose owns a horse. He owns a horse and enters into a contract with Aurora. So Aurora says that I'll buy your horse. It's okay. And she pays 50,000 rupees in return. That's simple, right? So the morning when Aurora goes to Bose's house for delivery, the horse is dead. So they both believe the fact that the horse was alive when they both entered into the contract. And when checked, the horse was dead. So the contract automatically gets cancelled because there was a mistake of fact regarding the terms of contract by both parties. And my friends, this is bilateral mistake. I hope you understood this. And mistake of law and mistake of fact by one party is not very much important, but I want you to remember these legal maxims. So most of your CLAT paper will only be regarding section 20, which is mistake of fact only, and some part of mistake of law. Let's just learn it some other time. You'll learn this in criminal law also, and I don't want to brag it a lot. So I hope you understood what mistake of fact is, and mistake under Indian Contract Act is defined under section 20, 21 and 22. Let's move to the next slide, where we'll be learning about lawful consideration. As we all know, a contract, when needs to be formed, it must include the following ingredients. The first one, it must include an offer, who is an offerer, and it must include an acceptance by the offeree, and also a lawful consideration which is considered legal in the eyes of law. Then and only the contract is formed. And with the red highlighted word over here called consideration is what we'll be learning as our last topic of our second part. So consideration can be anything, except it must not be illegal in the eyes of law, it must not be immoral, it must not be fraudulent, or it must not be opposed to the public policy. Consideration can be something which is considered in the eyes of law, which is legal, which can be money, which can either be money, currency like dollar, rupee, yen, ruble, etc., or anything which is money's worth. So let's say, and anything which is money's worth is derived from barter system, where you exchange a good for another good. So consideration in simple terms I've mentioned here. Consideration is equals to something in return for a promise. It's that simple. So consideration must not be illegal, something which is not against law, and it is legal. So it must not be immoral. So there's a difference between moral and immoral. Both are opposite words to each other. So moral is something which is considered pure, which is considered refined in the eyes of society. So let's say, for example, immoral. So I say I have a stylus, and a person wants to buy it. I want to sell my stylus. So he thinks that he's paying money's worth, or he's paying me something which is worth the stylus. But in return, he's giving me something immoral considered to the society. He's giving me obscene material, which is considered immoral in the eyes of law. And also in return, he's giving me a packet of cigarettes. He's giving me a bottle of alcohol. That is immoral in the eyes of law when you exchange something which is moral. And next one is fraudulent. It must not be fraud, as we have learned it in the last slide. It must not be something which is considered fraudulent. And another thing, opposed to the public policy. As we have studied that in general, anything in exchange of a promise is either money or either money's worth. That's it. But there are a few exceptions under Indian Contract Act, and these exceptions are defined under section 25(1), 25(2) and 25(3). So you call it as 25 subsection 1, subsection 2 and subsection 3. So first major exception is natural love and affection. So let's say, for example, you have your grandfather. So you have a grandfather and you're his granddaughter or grandson. So your grandfather writes your name in his will. He writes your name in his will. You have done nothing to your grandfather. You're just really close. He loves you. they love you, either your grandfather or father, they love you. That's the reason why they have written your name in the will, which is considered as gifts or any affection towards a close family member. Next one, past voluntary services. Let's say you have both people, A and B. So A actually helped B in COVID time. So in 2020, many of them lost jobs, unemployment was at peak, and many of them were skilled but unemployed. So A was a really rich man. He helped B. He gave B a few funds to survive in that hostile situation. And B, later in 2023, when the pandemic ended, he offered some voluntary services to A, such as working in his company, working in A's company for free for next 3 months, or to cover the amount which he has given to B to survive. Next one, time barred debt. Time barred debt is something which is confusing for the first time learners. So time barred debt is nothing but, let's again take the example of A and B. So you have A here, you have B. So A has lent B 10,000 rupees, and B said with a promissory note that he will the period for repayment of this loan was for 3 years. A sues B after 3 years. So the time barred debt was 3 years. After 3 years, the B has to pay 10,000 rupees to A back again, but he didn't. So he sued against B in the court, where he said, this man has not paid my debt which I lent him 3 years ago. So now B says with a written note again, give me 1 month of time, I'll repay it back. And court considers this. So there's an offer, acceptance, and there's a consideration. So this is a exception of a consideration where a party writes a written promise to pay a debt by limitation. So I hope you understood law of contracts. I hope you understood law of lawful consideration and also the free consent part. So I hope you like this video. You share it with your peers, you share it with your coaching members, and just invite them for our free trial. Thank you all. Jai Hind, Jai Bharat.